categories లో నువ్వు ఎఫ్ఐఆర్ డైరెక్ట్ గా చేయనక్కర్లే, ఈవెన్ దో ఇఫ్ ఇట్ ఈస్ అ కాగ్నిజబుల్ అఫెన్స్. దే ఆర్ మ్యాట్రిమోనియల్ డిస్ప్యూట్స్, కమర్షియల్ అఫెన్సెస్, మెడికల్ నెగ్లిజెన్స్, కరప్షన్ కేసెస్, కేసెస్ వేర్ దేర్ ఇస్ అబ్నార్మల్ డిలే ఇన్ ఇనిషియేటింగ్ యాక్షన్. దీనికి కూడా ఏంటంటే వాళ్ళు గైడ్ లైన్స్ ఇచ్చారు ఆ కేసులోనే 7 days. సో ప్రిలిమినరీ ఎంక్వైరీ 7 days. 7 days తర్వాత ఎఫ్ఐఆర్ చేయాలో లేదో హీ హ్యాస్ టు డూ ఇట్. సో దిస్ ఈస్ ఆల్సో another landmark case, Lalita Kumari versus Government of UP in 2014. Okay, where it said that the FIR is mandatory immediately after complaint. The third case is basically Arnish Kumar versus State of Bihar. So in this case, there was a misuse of Section 495A, which is basically domestic violence. Many arrests for dowry harassment turned out to be unsupported or on inquiry. What safeguards apply to arrest in persons of Section 495 and other offences punishable with imprisonment up to 7 years? So in this ఇష్యూ ఏంటంటే 495A బేసికలీ డౌరీ హెరాస్మెంట్ కోసం పెడుతున్నారు. సో వాట్ ఆర్ ద సేఫ్ గార్డ్స్ అంటే అది జెన్యున్ కేసా కాదని, వాట్ ఆర్ ద సేఫ్ గార్డ్స్ దట్ ఆర్ నీడెడ్ వెన్ యూర్ డూయింగ్ 495. దిస్ ఆల్సో ఇన్ 2014 ఇన్ స్టేట్ ఆఫ్ బీహార్. సో సుప్రీం కోర్ట్ గైడ్ లైన్స్ ఏం చెప్పిందంటే, ఫర్ offences up to 7 years imprisonment, arrest is not automatic. Police must record reasons behind arrest. Especially Section 41 CrPC must be compiled with notice of appearance to be issued where arrest is not necessary. So 41 CRP notice ఇచ్చి వాడిని వచ్చి అసలు వాడు ఎందుకు అని చెప్పాలన్నమాట. Arrest must be justified on parameters: preventing further offense, proper investigation, preventing tampering of evidence, preventing document witness, and inducement of witness, and accused appearance at trial. So magistrates must scrutinize arrest justification before remanding accused. So anyway, 24 hours లోపల అరెస్ట్ చేయగానే తీసుకెళ్తారు కదా, magistrate should scrutinize, especially in 495 cases, if the whatever the documents which the police is submitting are justifying the person's arrest. Failure to comply may result in departmental action against the police officer. So significance ఏంటంటే, reinforce Section 41 introduce checklist approach to arrest in non-serious offenses. So domestic violence లో ఏంటంటే they've created a checklist where they are అంటే అది జెన్యున్ కేసో కాదో తెలుసుకోవడానికి ఫస్ట్ నోటీస్ ఇచ్చినాక there are certain steps which they have to follow, and based on that only అరెస్ట్ చేయాలన్నమాట. అంటే జెన్యున్ డొమెస్టిక్ వైలెన్స్ అయితే వాడిని అరెస్ట్ చేయొచ్చు అనమాట. Sorry. This last లో ఉంది కదా, Section 15, 14 and then 15. Okay. So that's the third case. And what is DK Basu అయిపోయింది. Then we have gone into 1 minute. Let me shorten it so I can see 2 pages. So Arnish Kumar case is also very important. So 3 landmark cases, please remember. DK Basudi, next Lalita Kumari, next Arnish Kumardi. And then there are other cases. For example, this case, Joginder Kumar versus State of UP, which is 1994 case. This was pre-DK Basu case, where they said that right to be informed of grounds of arrest, right to inform a friend of relative, right to consult a lawyer. ఈ 3 చెప్పారనమాట బిఫోర్ ద DK Basu 11 పాయింట్స్ వచ్చినప్పుడు అరెస్ట్ గురించి. And then another case, Selvi versus State of Karnataka, narco analysis, polygraph and brain mapping tests are violative of Article 20 if conducted without consent. So without consent, ఈ 3 చేయకూడదు. Even with consent, results are not admissible substantively, only as fruits permittive derivative evidence. సో ఈ 3 టెస్ట్లు, పాలిగ్రాఫ్ టెస్ట్లు ఇవన్నీ చేసినప్పుడు ఈ 2010 కేసులో వాళ్ళకి ఏం చెప్పారంటే, రిజల్ట్స్ ఆర్ నాట్ అడ్మిసిబుల్ సబ్స్టాంటివ్లీ. అంటే ఇట్ కెనాట్ బి అ డైరెక్ట్ ఎవిడెన్స్, ఇట్ కెన్ బి అ డెరివేటివ్ ఎవిడెన్స్. Another case, Hussainara Khatum versus State of Bihar, which is a very old case, 1979. Right to speedy trial is a fundamental right under Article 21. Free legal aid is constitutionally mandated for indigent accused. Highlight the plight of under trials in jails. So basically ఈ కేసులో వాళ్ళకి ఫ్రీ లీగల్ ఎయిడ్ ప్రొవైడ్ చేసినట్టున్నారు. And yeah, so basically these are the 6 or 7 cases which we have discussed, and there are multiple other cases in the అంటే ఇంకో 2-3 కేసెస్ ఉన్నాయి, బట్ దీస్ ఆర్ ఆల్ సంథింగ్ విచ్ ఆర్ వెరీ ఇంపార్టెంట్. లైక్ జోగిందర్ కుమార్ వర్సెస్ స్టేట్ ఆఫ్ యూపీ కూడా ఉంది. రైట్ టు బి ఇన్ఫార్మ్డ్ ఇఫ్ ద గ్రౌండ్స్ ఆఫ్ అరెస్ట్ ఒకటి. మొహమ్మద్ అహ్మద్ ఖాన్ వర్సెస్ షాబానో బేగం, బేసికలీ ఇది మెయింటెనెన్స్ గురించి. ఇట్స్ ఎ ల్యాండ్ మార్క్ కేస్. అండ్ డానియల్ లతీఫీ వర్సెస్ యూనియన్ ఆఫ్ ఇండియా విచ్ ఇస్ ముస్లిం ఉమెన్ యాక్ట్ మస్ట్ బి రెడ్ విత్ అంటే మెయింటెనెన్స్ ముస్లిం ఉమెన్ యాక్ట్ కూడా అప్లికబుల్ అవుతుంది అని చెప్పారు కదా డానియల్ లతీఫీ కేసులో 2000. And State of Punjab versus Raj Singh, observations of Section 195 and stage at which the bar to cognizance operates. And cognizable, non-cognizable, అది ఎట్లా అనేది సెక్షన్ 195లో డిఫైన్ చేస్తారు. And State of Karnataka versus Yarappa Reddy. So IO can, investigating officer can refer to case diary to refresh memory under Section 172. Okay. So these are some landmark cases, and the last one is Sheila Burse versus State of Maharashtra, which is basically right of female prisoners, safeguard for women in custody, custodial rights గురించి చెప్పారన్నమాట. Okay, so yeah, so we have gone through these cases, and then there is a this is purely, I think, BNSS, which is basically the comprehensive comparison of BNSS and CrPC, which we have done almost yesterday. We were reading both the sections. So here is a table where if you want to look for a particular area, police arrest without warrant under Section 41, whereas in BNSS is Section 35. Okay, largely the same. So ఇవన్నీ ఉన్నాయి. నిన్న most of these topics we have covered, and important topics in this BNSS ఏంటంటే ఒకటి zero FIR, which is codified, and then EFIR introduced, electronic registration, and Section 37, which is designated officer in each district for arrest information. Section 86 is foreign property, అంటే ఇప్పుడు ఫారెన్ లో ఉన్న ప్రాపర్టీని కూడా అటాచ్ చేయొచ్చు అనమాట BNSS ప్రకారం. Next, forensic team mandate for offences is greater than 7 years of imprisonment. Okay, forensic team ni మీరు తీసుకోవచ్చు for offences which are greater than 7 years. Section 290 BNSS is 30-day time limit for plea bargaining. This 30-day time limit of plea bargaining is after the framing of charges. Okay, just remember that. And Section 356 is the trial in absentia of proclaimed offenders. సో వాళ్ళు లేకుండా కూడా ట్రయల్ చేయొచ్చు అనమాట. వేరేస్ ఇన్ సిఆర్పిసి వాళ్ళు లేకుండా ట్రయల్ చేయరు. ఇందులో సెక్షన్ 356 absconding, like Vijay Mallya left, but his trial will continue in India. Section 530 trial in electronic mode, like virtual hearings. And Section 346 strict adjournment restrictions, అంటే లాయర్ రాలేదు కాబట్టి ప్రతిసారి అడ్జర్న్మెంట్ ఇవ్వడానికి లేదు. దెర్ ఈస్ అ టైమ్ లిమిట్ విచ్ దే ఫిక్స్డ్ అండ్ సెడ్ మల్టిపుల్ అడ్జర్న్మెంట్స్ ఇవ్వడానికి లేదని. Section 531 is repeal of CrPC 1973. Okay, so these are all the innovations in BNS which is not there in CrPC. So if you look at which section of BNSS repeals the Code of Civil Procedure, హెమాలి గారు నిన్న మనం సెక్షన్ 531 గురించి చదివాం కదా. Are you there?
Yes, I'm there, sir.
Do you remember what the section is?
531 we read also. I don't remember.
531, section 531 BNSS.
No, I don't remember. But here it's given it repeals the entire criminal procedure code, no?
So 531 acts as a repeal and savings clause, replacing the old CrPC effectively June 1st, 2024. సో
Oh,
జూన్
yeah,
ఫస్ట్
ఇక్కడ
తర్వాత జూలై
repealed
ఫస్ట్
ఉంది. Okay, okay, okay.
జూలై ఫస్ట్ తర్వాత కేసులన్నీ BNSS లో వేయాలి. I think that's what it means. Yeah.
Yes, yes, yes.
So there was a question: which section of BNS repeals the Code of Civil Procedure 1973? It is 531.
One.
They have asked in AIB 19. 2 years ago they have asked. And so basically these are all the topics which we have covered. I think we have reached the end of the section. These are all summary of different things. If you want to brush up and look at different topics, ఇవన్నీ ఉన్నాయి. పబ్లిక్ ప్రాసిక్యూటర్ సెక్షన్ 24 అయితే BNSS లో 18 ఉంటుంది. అన్ఫార్చునేట్లీ మనకి ఎగ్జామ్కి 2 ఉన్నాయి. CRPC ఉంది, BNSS కూడా ఉంది. Both of them are there, so they can ask questions from both of them. Okay. And yeah, so that's what most of the things are. So we have covered the important cases which they might ask, and also cross references between BNSS and CRPC. So that ends our third section, and I think we can move to the fourth section, which is basically the Indian Penal Code or BNS. So Bharatiya Nyaya Sanhita. Okay, should I go ahead?
I have one question. This is Nirmala. Can we take both CRPC and BNSS books into the classroom? I mean, into the exam hall?
Yeah, you can. You should actually. మీకు సిలబస్లో ఉంటే మరి తీసుకెళ్ళాలి కదా మేడం. You can take 19 to 20 books. Whatever is applicable in AIBE, all the acts you can take.
Okay.
Okay. So we'll go to the fourth section. Fourth section, no, na దగ్గర 1 minute, guys. I'll just open it. I don't think I have just that part. నేను బ్రౌజర్ క్రాష్ అవుతుందని because the book is big, I was just making them into parts. Okay. So you have finished all this, కదా? Maintenance అయిపోయింది, landmark cases finished.
Maintenance yesterday.
Yeah. Yeah, I think one of the things which we missed in that is CRPC law. There are like some questions which we have missed. One of the question, I think we'll just go through that quickly. One is given below two statements, one labeled as assertion and the other one labeled as reason. So ఇవేంటంటే assertion reason questions last 2 years నుంచి అడుగుతున్నారు అన్నమాట. So what is assertion? Any person having an interest in newspaper declared forfeited may apply to the High Court to set aside the declaration within 2 months of its publication in the gazetted official gazette. Reason: the special bench of High Court to hear such application must always consist of exactly 3 judges regardless of the strength of the High Court. In the context, which of the above assertion and reason are correct? So ఇది ఏంటంటే both లేకపోతే A is correct and R is incorrect? Which of the thing is assertion and reason? So this what is the answer అని అడుగుతున్నారు అన్నమాట. I think నిన్న చేశాం కదా హేమాలి గారు ఇది.
అవును సార్ చేసాం. We did this.
Yeah. So I think the answer is the assertion is correct that forfeited
R is false.
R is false. Yeah. Because the special bench of High Court exactly 3 కాదు 3 or less ఉండొచ్చు. That's what you said, right? Yesterday.
అవును సార్. అవును.
Okay. So another question is under section 397 of BNSS, a police officer acting in good faith is which section? So basically the answer is 397, section 397. Okay. And iదేంటి under BNSS 2023, section 18 provides punishment and enhancement of punishment enhancement. Section 18 provides punishment enhancement of 5 years under. So again, under CrPC, the rule regarding evidence requires life imprisonment or imprisonment exceeding 2 years. So ఇవన్నీ
దేంట్లో
ఏంటంటే
ఆన్సర్ అసలు ఐ డోంట్ రిమెంబర్ దిస్. These are
ఇవన్నీ
extra questions, extra
ఇవన్నీ
questions.
ఎక్స్ట్రా అవుట్ ఆఫ్ ద సిలబస్ అనమాట. ఏ టాపిక్ కి లేకుండా బట్ దే ఆర్ రిలేటెడ్ టు ద చాప్టర్. సో బేసిక్లీ ఐ థింక్ దిస్ ఆర్ ఏఐబి 12 అడిగినట్టున్నారు ఇవన్నీ. చాలా weird questions. And CrPC BNSS regarding procedure. 30 days for all offenses. Procedure should start in 30 days, I think. So, and under section 320 of CrPC, compounding of offenses. Sorry. Hello. ఇది మనం సివిల్ ప్రొసీజర్ కోడ్కి వెళ్ళాలి కదా. Did I open the wrong file? Hello. Yeah, 1 minute, guys. It's online bit. Did I send these files to you guys? The latest one?
And V30.
V3 కదా. 1 minute. Let me just. I'm just worried. I'm just gone through the wrong file. And I made a lot of corrections. I think I put that online or something. Ganesh, 1 minute, guys. అందుకని ఎప్పుడు బుక్ చేసినా I keep sharing so that I don't lose. Okay. So anyway, let me open file and then quickly go through it. B30 study companion. Okay. I opened version 25. It was an old version. Yeah, అనుకుంటున్నాను. What is this? So the fourth topic, which is basically Indian Evidence Act. Okay. Yeah, Nish Kumar, correct. ఇవన్నీ అయిపోయినాయి. And then We went into Indian Penal Code. Yeah, this is the correct file. So I opened version 25 in that. Sorry, guys. Can you guys see? Hello.
Yes, we can see, sir.
Okay, okay. Okay. So the fourth topic is Indian Penal Code or Bharatiya Nyaya Sanhita. The Indian Penal Code 1860 is Indian Principal Criminal Code defining offences and prescribing punishment. It has been replaced by Bharatiya Nyaya Sanhita 2023, which has come into force on 1st July 2024 alongside the BNSS and BSA, replacing the IEA. Okay. So extend and extraterritorial application. So section 3 of IPC, punishment of offences committed beyond India, but within its territorial waters. That's what is section 3 defines in IPC. Section 4, extension of court to extraterritorial offences. The IPC applies to any citizen of India in any place without and beyond India, any person on any ship or aircraft registered in India, any person in any place without any beyond India which commits an offense targeting a computer resource located in India. So IPC applies to all three. So basically, any citizen of India, ikkadunna, baitunna, any person who is in our ship or in our aircraft, it is applicable to him. Any person in place without and beyond India who commits an offense targeting a computer resource in India. సో ఎనీ పర్సన్ అసలు ఫారినర్ అయి ఉండొచ్చు, ఫారిన్ ల్యాండ్లో అయి ఉండొచ్చు, మన కంప్యూటర్స్ని టార్గెట్ చేస్తే బేసికలీ హ్యాకర్స్. సో వాళ్ళకు కూడా ఐపీసీ అప్లికబుల్ అవుతుంది. The IPC doesn't apply to offense committed by foreign national outside India unless they're targeting Indian infrastructure. So an offense committed by a foreigner in a foreign country is a situation where IPC may not apply, except for basically if they're targeting our infrastructure or computer resources and things like that. So what are the key changes in BNS? The BNS Bharatiya Nyaya Sanhita replaces IPS. Key differences ఏంటంటే section sedition. Sedition is not retained as a standalone offense in BNS, replaced by section 152. Acts endangering sovereignty union of India, wider and differently worded. Second, BNS introduces organized crime, terror activities and snatching as new specific offenses. So organized crime, terrorist acts, snatching, ఈ మూడు యాడ్ చేశారు అన్నమాట. డెత్ పెనాల్టీ యాడెడ్ ఫర్ గ్యాంగ్ రేప్ ఆఫ్ మైనర్స్. Section 70 BNS idokati new thing which they've added. BNS also numbers all sections. IPC section numbers do not correspond to BNS section numbers or not. So BNS numbers or IPC numbers obviously match kavu. And this is, I think, quick summary of what we have studied. Section 4 of IPC. Remember, Section 4 of IPC is about extraterritorial citizens who ships మీద ఉన్నోళ్ళు or Indians, India targeting చేసే cyber offenses మీద. And BNSS effective 1st July 2024. So what they have added is basically sedition separate section చేశారు, and then organized crime, terrorists, snatching ఇవన్నీ యాడ్ చేశారు. Okay. So if you go to the questions, what they've asked in the last 10 years. So AIB 15 they've asked a question now, the provision of Indian Penal Code apply also to any offense committed by. So first is any citizen of India in any place, any person or ship or registered, or any person in place without any beyond targeting a computer. This is already we have studied. So answer is all of the above. Okay. And the second question is, in which of the following situations Indian Penal Code 1860 may not apply? Offense committed by Indians outside India, offense committed by person on a ship registered in India, offense committed by person committing offense targeting computer resource located in any country. So same question, Malli, any person committing offense targeting computer resources located in any country. Okay. ఇక్కడ వాడు స్మార్ట్గా ఏం రాశాడు, లొకేటెడ్ ఇన్ ఇండియా రాయలేదు, కంప్యూటర్ రిసోర్సెస్ లొకేటెడ్ ఇన్ ఎనీ కంట్రీ. సో ఆన్సర్ ఈజ్ 3. 3 ఈజ్ నాట్ అప్లికబుల్. ఐపీసీ విల్ నాట్ బి అప్లైడ్ టు హిమ్. సో వాడు అమెరికాలో ఉండి ఇఫ్ హీస్ హ్యాకింగ్ సమ్ పాకిస్తాన్ దిస్ థింగ్, హౌ ఆర్ వీ కన్సర్న్డ్ అబౌట్ ఇట్? ఐపీసీ మైట్ నాట్ అప్లై. ఓకే. Next, general principles of criminal law. The subchapter 9 previous questions and covers the fundamental doctrines in which criminal liability rests. So, mens rea, actus rea, punishments, and their quantum. So, general principles, mens rea, actus rea, I think మనం ఎన్ని చదువుకున్నాము. So, the maxim actus non fecit reum nisi mens sit rea. So this maxim means that the act does not make a person guilty unless the mind is also guilty. Okay. Only act doesn't make him guilty. It has to act. అంటే మెన్స్ రియా కూడా ఉండాలి, యాక్టర్స్ రియా ఒకటే ఉంటే సరిపోదు. That's what it means. So guilty mind, mens rea, then mental environment, and the wrongful act, the external act of omission. So punishment under IPC, which is section 53, enumerates the punishment: death, imprisonment. Next, imprisonment of two descriptions: rigorous and simple. And the fourth one is forfeiture of property. 5 is fine. So these are the 5 types of punishments. So you should remember this. One is section 53 కింద 5 different type of punishments ఇవ్వచ్చు. డెత్ ఇవ్వచ్చు, ఇంప్రిజన్మెంట్ ఆఫ్ లైఫ్ ఇవ్వచ్చు. థర్డ్ జస్ట్ ఇంప్రిజన్మెంట్ ఇవ్వచ్చు, కానీ అది రిగరస్ ఉంటుంది, సింపుల్ ఉంటుంది. ఫోర్త్ వాడు ప్రాపర్టీ మొత్తం ఫార్ఫిట్ చేయొచ్చు. 5 is ఫైన్ ఇవ్వచ్చు. ఓకే, ఆల్రెడీ ఒక ఎగ్జామ్లో అడిగారంట, సో రిమెంబర్ దిస్. Section 53. Next, solitary confinement under BNS. So under BNS, the maximum period of solitary confinement in any stretch is 14 days. So BNS lo ఇది యాడ్ చేశారు, solitary confinement 14 days కన్నా ఎక్కువ ఉండకూడదు అని. So imprisonment of mine is equal to 20 years for calculating fractions. So section 57, for the purpose of calculating fractions or terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. Okay, section 57 ఏమంటుందంటే imprisonment for life అంటే that means it is for 20 years. Section 72, punishment for doubtful offences. In case if where it is doubtful or several offences have been committed, the court shall award the punishment provided for the offences the lowest punishment. Okay, least severe. So section 72, multiple offences చేసాడు అన్నప్పుడు the court shall under section 72 can take the least offense అంటే least punishment తీసుకుని కూడా ఇవ్వచ్చు. ఈజ్ ఇంపార్టెంట్. ఇది లాస్ట్ ఇయరే అడిగారు, AIBE 20లో అడిగారు. ఓకే, and fine, default imprisonment under BNS. So section 8, when the offense is punishable with fine only. If the fine is under 200, maximum 1 month default punishment. If the fine is between 200 to 500, maximum 2 months. If the fine is 500 to 1000, so this is maximum 3 months. So basically when the offense is punishable under fine, a fine, I think a fine కూడా వాడు కట్టలేకపోతే దానికి ఈక్వలెంట్ ఇన్ని months they are giving as punishment. So if the fine is 4,000, maximum punishment is default is 2 months. So okay, 2 months, 4,000 fails bracket, so 2 months is maximum. 2 months is maximum, you have to remember that. Okay, maximum is 3 months. 5,000 to 1,000 is 3 months. Okay, next another thing is section 89, so which is non-pecuniary benefit. Section 89 of IPC, act done in good faith for benefit of child or insane person by consent of guardian. Use the word benefit in a non-pecuniary sense. The benefit does not include pecuniary benefit under section 89. So basically you need a benefit. Benefit means ఇది డబ్బులు కాదు, pecuniary కాదు. It is benefit in terms of good faith, especially when children, insane person or guardian consent తో చేయొచ్చు అనమాట. అది గుర్తుంచుకోవాలి. బెనిఫిట్ సెక్షన్ 89 బెనిఫిట్ అంటే అది మనీ బెనిఫిట్ కాదు అని గుర్తుంచుకోవాలి, ఎందుకంటే అది ఎగ్జామ్లో అడిగారు. సో ద ఫస్ట్ క్వశ్చన్ we have like based on the information we have, which is basically the core general principles of criminal law. What are the different questions they are asking? So the first question is the punishment to which offenders are liable under the provision of IPC are. death and imprisonment, rigorous imprisonment, forfeiture of property and fine, all of the above. సో బ్రాడ్లీ ఐపీసీ కింద ఏముంటుంది, డెత్ ఉంటుంది, ఇంప్రిజన్మెంట్ ఉంటుంది, లేకపోతే ఇంప్రిజన్మెంట్ రిగరస్ సింపుల్ ఉంటుంది, టైమ్ లైన్ కెన్ బి ఎనీథింగ్, దెన్ ఫార్ ఫీచర్ ఆఫ్ ప్రాపర్టీ ఉంటుంది, ఫైన్ ఉంటుంది. సో బేసికలీ ఆల్ ఆఫ్ ద అబౌవ్. Now the next question is the maximum actus not fecetrium nisi mens citria means. What does it mean, guys?
A.
Yeah. So ఇప్పుడు మోటార్ యాక్సిడెంట్ అయింది, ఎవరన్నా వచ్చేసి గుద్దేశారు, గుద్దేసి చనిపోయారు. సో విల్ ఇట్ బి మర్డర్ ఆర్ విల్ ఇట్ నాట్ బి మర్డర్?
No, it's not murder. There's no
Yeah.
guilty mind.
యా. సో వాడు ప్రీ ప్లాన్ చేయలేదు కదా, అక్కడ వచ్చి ఎగ్జాక్ట్గా వీడిని గుద్ది చంపేస్తాను. సో ఇట్ జస్ట్ అన్ యాక్ట్, దెర్ ఇస్ నో మెన్స్ రియా ఇన్ ఇట్. సో దెర్ విల్ బి డిఫరెంట్ సెక్షన్ ఫర్ దట్. ఓకే. నెక్స్ట్, నేమ్ టు ఎసెన్షియల్ కండిషన్స్ ఫర్ penal liability. సేమ్ థింగ్, టూ కండిషన్స్, యాక్టర్స్ రియా, మెన్స్ రియా. సో గిల్టీ మైండ్ ఉండాలి, రాంగ్ఫుల్ యాక్ట్ ఉండాలి. How many types of punishments are currently existing under Indian Penal Code? How many types?
5.
5. Yeah. Death, imprisonment, rigorous simple imprisonment, forfeiture of property, fine. Which of the following sections of Indian Penal Code the word benefit does not include pecuniary benefits?
89.
89. Yeah. And then question number 6. Under Bharatiya Nyaya Sanhita, last year అడిగారు, what is the maximum number of consecutive days an offender must be kept in solitary confinement at a time?
14 days.
14 days. Next, again same thing, last year అడిగారు, under the BNS 2023, if a person is ordered to pay a fine of 4,000 but fails to do, what is the maximum simple imprisonment the court may impose on the defaulter? సో 4,000 కట్టాలి వాడు ఫైన్, వాడు కట్టలేకపోతున్నాడు, కట్టలేనప్పుడు ఇంప్రిజన్మెంట్ చేస్తారు. ఇంప్రిజన్మెంట్, ద టర్మ్ ఆఫ్ ఇంప్రిజన్మెంట్ ఇన్ డిఫాల్ట్ షెల్ నాట్ ఎక్సీడ్ 2 months when the fine doesn't exceed 5,000. సో బిఎన్ఎస్ లాస్ ప్రకారం 5,000 కన్నా తక్కువ ఉంటే 2 months ఇవ్వాలి. ఓకే, 4 months 10,000 and 4 months అయితే doesn't exceed 10,000 and 1 year in case if it is more than 10,000. Okay, in any case. You have to remember this. Next, if multiple offenses carry a different punishment, but it is unclear which one has been committed, how does Section 42 of the Section 72 of the Indian Penal Code ensure proportional justice? The answer is by imposing punishment for the offense with the lowest prescribed item, by applying punishment equal to the average, by leaving the choice of punishment, by suspending the punishment until further clarification. I think మనం ఇందా చదువుకున్నాం కదా, ద జడ్జ్ హ్యాస్ దిస్ థింగ్ మల్టిపుల్ అయినప్పుడు దేంట్లో అయితే లీస్ట్ ఉందో అది he can give. So imposing punishment of the lowest prescribed term. Okay. So then another question is basically if a convict sentenced to life imprisonment is being considered for remission fractions under Section 57 of Indian Penal Code, which equivalent term of years is applied to the court? అంటే లైఫ్ ఇంప్రిజన్మెంట్ అంటే ఎన్ని ఇయర్స్? Section 57 ప్రకారం it is 20 years. Okay. Guys, any questions?
No, sir.
We can move out to the next thing, which are basically general exceptions in these IPC and CRPC. Ma'am, మీరు చదువుతారా?
నేనా?
Yeah, మీరు
నేను
కూడా చదవచ్చు.
హిమాలయన్ అడిగా బికాస్ ఐ మీన్ బస్ సో ఐ క్యాంట్ రీడ్.
నో ప్రాబ్లం. హిమాలయ గారు చదువుతారు. హిమాలయ గారు ఓకేనమ్మా?
Yeah, it's fine, sir. Yeah. So general exceptions. This is the most heavily tested subchapter. So with 14 PYQs, it covers all the defenses that excuse or justify otherwise criminal acts. So master the section 76 to 106 carefully. Overview of general exceptions. Chapter 4 of IPC, that is section 76 to 106, set out general exceptions, circumstances. General exceptions and circumstances in which an act would otherwise be an offense is not considered as an offense. So what are they? These include mistake of fact, judicial acts, accident, acts without criminal intention, infancy, insanity, intoxication, consent, good faith, communication, and private defense. So 76 to 106. This is the list. దీంట్లో ఇంపార్టెంట్వే ఉన్నాయి 76, 77, 80, 82, 84, 85, 87, 88 and 96. Okay, so first one is act under mistake of fact, section 76 of IPC. Nothing is an offense done by a person who is or who by reason of a mistake of fact in good faith believes himself to be bound by law. Nothing is considered as an offense by a person who by reason of a mistake of fact, not by mistake of law, by mistake of fact, in good faith, believes himself to be bound by law. Section 79 is nothing is an offense done by a person who, by reason of mistake of fact, in good faith, believes himself to be justified by law. Both sections 76 and section 79 require mistake of fact. You have to remember that, not law, and good faith belief. Belief in good faith. Okay. So next one is act under court order. Section 78 of IPC. Nothing is an offense done by a person in pursuance of and in conformity with the judgment or order of the court if that person acts in good faith, even if that court had no jurisdiction, provided the person acted in good faith. Here, good faith is important. Act under court order, provided the person acted in good faith. 78 of IPC. So if a bailiff executes an eviction under a civil court order later declared void for lack of jurisdiction, the bailiff is exempt if he acted in good faith. This was exam tested. I'll just read this again. If a bailiff executes an eviction under a civil court order later declared void for lack of jurisdiction, even if the court lacks jurisdiction, also the bailiff is exempt if he has acted in good faith. Okay. Next one is accident. That is section 80 of IPC. Nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge, no mens rea. Okay, in doing of a lawful act in a lawful manner by lawful means and with proper care and caution. So classic illustration also AIB tested is A is at work. A is at work with a hatchet. The head flies off and kills a man standing by. So if there was no want of proper caution on A's part, it is not considered as an offense under section 80. So it was an accident. So it's not considered as an offense. Next is infancy. Sections 82 and 83. Nothing is considered as an offense which is done by a child. Child under 7 years of age. We have to remember this, 7 years of age. Below 7 years of age, this is the doctrine of doli incapax, that is incapable of crime. So, child below 7 years is incapable of committing a crime. This was also exam tested. That is called as doctrine of doli incapax. 82. Section 83. Nothing is an offense which is done by a child above 7 years of age but below 12. So, first is below 7, that is 82, 83, 7 to 12, and who has not attained sufficient maturity of understanding to judge the nature and consequences of the conduct. So, under 7 is absolute defense, 7 to 12 is defense only if insufficient maturity, above 12, no infancy defense. So, above 12, you cannot claim that infancy defense. Under section 82 and 83, An offense is punishable if done by a child above 7 years of age but below 12, having attained sufficient maturity. This was exam tested. Okay. So 7 to 12 defense only if there is insufficient maturity. That we have to remember. Okay. Next is insanity. Section 84, McNaughton rules. McNaughton rules. There was one case law, I think. Okay. Section 84 of IPC. Nothing is an offense done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. So he's incapable of knowing the nature of the act, or he's incapable of that he's doing what is either wrong or contrary to law. Okay. The McNaughton rules, House of Lords, form the basis of law of insanity in criminal law. This was also exam tested. We have to remember this. McNaughton rules. They form the basis of law of insanity. Okay. Uh, Given in section 84. 84, Z, under the influence of madness, attempts to kill X. So Z has not committed any offense because he's protected under insanity. This section 84. Okay. X still has the same right of private defense. Section 98 of IPC. Right of private defense against an insane person is preserved even though the act is not considered as an offense. This was also exam tested. X still has the same right of private defense. Right of private defense against an insane person is preserved even though the act is not considered as an offense. Okay. Next is consent, section 87. The act not intended and not known to be likely to cause death or grievous hurt done by consent. Where two or more persons agree to engage in an activity with mutual consent, accepting the risk of harm, but not death or grievous hurt, the resulting harm is not considered as an offense. Illustration ఏంటంటే A and B agree to fence with each other for amusement. A hurts B. In the course of fencing, it is not considered as an offense. It is under section 87. This was also exam tested. Okay. So both of them have engaged in an activity with mutual consent. Harm aina kuda, it is not considered as an offense because it was done through consent. Section 90 of IPC, consent given under fear of injury or misconception of fact, or by a person of unsound mind or intoxicated, or a child under 12, is not a valid consent. This is also exam tested. Section 90. I'll read it again. Consent given under fear of injury or misconception of fact, or by a person of unsound mind or intoxicated, or child under 12, is not considered as a valid consent. So, okay. Answer is all the above. All these were given as options. So, answer is all of the above. Private defense, section 96. 96 to 106 of IPC deals with right of private defense. This was also exam tested. Right of private defense, A sections లో వస్తాయంటే 96 to 106 of IPC. Section 96, nothing is an offense done in the exercise of the right of private defense. 97 is right to defend a person or property. 98 is right of private defense against the act of a person of unsound mind, even if the attacker has a general exception. The person attacked retains the right of private defense. So that means even if the person is attacked by a person of unsound mind, this person can still has the right of private defense. This was given in section 98. Okay, section 100 is when the right of private defense of the body extends to causing death. 5 situations ఏంటంటే assault reasonably causing apprehension of death, assault reasonably causing apprehension of grievous hurt, assault with an intent to commit rape, assault with intent to commit unnatural offense, assault with intent to kidnap or abduct, assault with intent to wrongfully confine with apprehension of inability to recourse to public authorities. So there are 6 situations here. The right of private defense of the body extends to causing death. So the right of private defense does not extend to causing death when the assault is only reflecting intention of causing simple hurt. This is also exam tested. Right of private defense does not extend to causing death when the assault is only reflecting Can somebody tell us what is the meaning of this? Right of private defense does not extend to causing death when assault is only reflecting intention of cause. Acha. Okay. Okay. Right of private defense of property extending to causing death. Section 103. The four situations where it extends to causing death is robbery, housebreaking by night, mischief by fire on dwelling, vessel, or vehicle, theft, mischief, house trespass, and circumstances of apprehension of death or grievous hurt.
Hello.
Okay. Yes, yes. I'm just sorry. I was just reading it again. Okay. Under BNS 2023, the right of private defense of property extends to causing death in robbery, and second one is housebreaking at night. This was also exam tested, both one and two. So, right to private defense of property extends to causing death in four situations where it causes death in four situations. Yeah, that is robbery, housebreaking by night, mischief by fire, theft, mischief, or house trespass in circumstances of apprehension of death or grievous hurt. So, in these four situations, right of private defense of property can be taken. Okay. Next is necessity. R versus Dudley and Stephens. So this was a famous case actually. Shipwrecked sailors killed and ate a cabin boy to survive. This was what was held is the court held that killing an innocent life to save one's own is not a valid defense. This so necessity is not a defense to murder. R versus Dudley and Stephens. Necessity is not a defense to murder. This was exam tested. We have to remember this. So I'll go ahead with the questions.
Yeah, go ahead. Yeah.
The A and B agree to fence with each other for amusement. This agreement implies the consent of each other to each to suffer any harm which in the course of fencing may be caused without foul play, and if A while playing fairly hurts B, A commits no offense. The provisions are given in which section? So it's given in section 87. If we have the Bear Act, it will be easy for us. Sections
Yeah.
this section 87. Okay.
సో బేసికలీ బేర్ యాక్ట్స్లోకి వెళ్ళి 87, 85, 86, 88 చూసుకొని ఏది కరెక్టో రాసుకోవాలి ఇఫ్ యూ డోంట్.
We don't remember. So the second one is the provision of right of private defense దేంట్లో వస్తుందంటే 96 to 106 of IPC. సార్ దీనికి కూడా బిఎన్ఎస్ ఐపీసీ రెండు కావాలా?
యా మన దరిద్రం ఏంటంటే ఈసారి రెండు ఉన్నాయి మనకి.
ఓకే. సో 3 థింగ్స్ డబుల్ అవుతాయి అనుకుంటా కదా, సిఆర్పిసి అండ్ ఐపీసీ అండ్ దిస్ ఎవిడెన్స్.
ఇండియన్ ఎవిడెన్స్ యాక్ట్.
సరే ఓకే. మెక్నాటన్ రూల్స్ ఫార్మ్స్ ద బేసిస్ ఆఫ్ లా ఆఫ్ ఇన్సానిటీ. ఓకే.
ఓకే.
So A is at work with a hatchet. The head flies off, kills a man who's standing nearby. So here, if there was no want of proper caution on the part of A, his act is an offense of murder, an offense of culpable homicide, not an offense causing grievous hurt. It's not considered as an offense. Okay, this is according to section 80. Because there was no without any criminal intention or knowledge in doing a lawful act by law in a lawful manner. Lawful means there was proper care and caution. So A's act is not considered as an offense. So BNS equivalent to section 18. It replaces section 80 of IPC. Okay. Under section 82 of IPC, nothing is an offense which is done by a child under age is 7 years. Okay. So the doctrine is, we have to remember, is doli incapax. So child below 7 is incapable of committing any offense. That is given in section 20 of BNS and 82 of IPC. R versus Dudley and Stephens stands for the principle that killing an innocent life to save his own is not a defense, and necessity cannot be pleaded as a defense against murder. Necessity can be pleaded as a defense against murder. killing an innocent life to save his own may become inevitable. C is killing out of mercy is a defense and necessity cannot be pleaded as a defense against murder. None of the above. So the answer is A. Killing an innocent life to save his own is not a defense. Necessity cannot be pleaded as a defense against murder. Okay, so this was a very famous English case. So shipwrecked sailors killed and ate a cabin boy to survive. You have to remember this. The Queen's Bench held that necessity is not a defense to a charge of murder. One cannot kill a innocent person to save one's own life. Okay, next is Z under the influence of madness attempts to kill X. So is Z guilty of an offense? Has X the same right of private defense which he would have had if Z were sane? Z has not committed any offense and he has private defense. This X person. The answer is A. Z has not committed any offense as per section 98 of IPC and the same right of private defense to X if Z is mad. Z is not mad, no? Z is sane.
Said under the influence of madness. Attempts to kill X.
No. In the options, the same right of private defense to X if Z is mad. Z is not mad, no? Z is was sane. I don't know
Z
why the
has,
question.
Z has not committed any offense as per section 98. As a private defense to that to that is Z is mad.
No, if Z was sane also, X would have still had private defense. కానీ ఇక్కడ Z insane కదా. So now also he has private defense. So అది తెలుసు మనకి. అది 98 లో ఉంది. అని క్వశ్చన్ ఆప్షన్ సేమ్ రైట్ ఆఫ్ ప్రైవేట్ డిఫెన్స్ టు ఎక్స్ ఇఫ్ జెడ్ ఇస్ మ్యాడ్ కాకుండా జెడ్ ఇస్ సేన్ అని అనాల్సి ఉండేది అనుకుంటున్నాను. బట్ ఎనీవే ఓకే.
If Z is sane, okay. ఈ వేరే ఇది యాక్చువల్లీ ఏఐబిలో చాలా మిస్టేక్స్ ఉంటాయి ఇంగ్లీషు ఇది.
ఓకే ఓకే సరే. Question number 8 is under section 82 and 83 of IPC. An offense is punishable if it is done by a child of below 7 years of age, of above 7 years but below 12, having attained sufficient maturity and understanding, of above 7 but below 10, having attained sufficient maturity and understanding. As a 10 lane ledu, so C can be eliminated. Of above 7 years of age but below 12, not having attained sufficient maturity and understanding. So 82, 83 ఏంటంటే of above 7, below 12, having attained sufficient maturity and understanding. The child
So
has
in
to attain maturity and understanding.
yeah, below 7 is Dolly in capex, right? So it has to be above 7 only. So you can eliminate A. మిగతా BCD is all above 7. So to fix above 7 అన్నప్పుడు below what అని we have to figure out.
Below 12. You have
12,
to remember below 12. The next one is provisions
ఇందులో
for right of
ఇందులో మల్టిపుల్ చాయిస్ లో below 12 having attained sufficient maturity, below 12 having not attained sufficient maturity. So if you look at it, I think answer will be obviously we don't know 10 కూడా అవ్వచ్చు.
12 ఉంది సార్, అది 12 years కదా.
అవునవును 12. No, I'm just saying if you don't know the answer,
అవునవును.
can we eliminate?
We don't know the below. We can't. It's difficult. We have to remember 7 and 12.
Yeah, sorry, go ahead.
Okay, next is provisions for right of private defense is given between dash of IPC 96 to 106. We have to read the, at least if we remember, or we have to check the bare at something. 96 to 106 is right of private defense.
Yes.
And the consent is not considered as a valid consent if given under fear of injury or misconception of fact, if given by a person of unsound mind, if given by child below 12 years of age. So all of these is the answer. 90 of IPC says, I don't remember this. Okay. 90 of IPC says consent is not consent if given under fear of injury. Yeah, person of unsound mind or intoxicated person who is unable to understand nature, or by person under 12 years of age. Okay. So 11th question is A and Z Mali they fencing for amusement. In the course of such fencing, of while playing fairly, A hurt Z severely. Which of the following offense is committed by A? Attempt to murder, grievous hurt, no offense, hurt. No offense. Answer is no offense. Okay. So next one is in which of the following situations right of private defense cannot extend to causing death? Cannot extend to causing death. Okay. In case where when an assault is causing apprehension of murder, assault is reflecting intention of committing rape, assault is reflecting intention of causing simple hurt, assault is reflecting intention of gratifying unnatural lust. Assault is reflecting intention of causing. I don't remember this at all. Rape or murder, I remember A and B. The simple hurt or grievous hurt, I don't remember that. Okay, I'll just read the answer. Section 100 of IPC enumerates the situations in which the right of private defense of the body extends to voluntarily causing death. These include reasonable apprehension of death, grievous hurt, rape, gratifying unnatural lust, kidnapping or abduction, etc. An apprehension of a mere simple hurt is not one of those situations. Okay. Okay. Simple hurt kaadu. Death, grievous hurt, rape, gratifying unnatural lust, kidnapping and abduction. Okay, they're all serious. So, right of private defense. Right of private defense in such a case is limited and does not extend to causing death. Answer is C. In case where assault is reflecting intention of causing simple hurt. Okay.
Okay.
So 13 is if a bailiff executes an eviction based on a civil court order later declared void for lack of jurisdiction, what protection does 78 of IPC provide? Bailiff is punishable as the order was invalid from the beginning. The bailiff can be punished only with a reduced penalty. Bailiff is exempt if he acted in good faith under the order. The bailiff is required to compensate the evicted person. Bailiff is exempt if he acted in good faith. In good faith thing, we have to remember this good faith. 78. So 78 of IPC provides protection to a person who's acting in good faith under a court order. So even if the order is later declared void for lack of jurisdiction, the bailiff who acted in good faith under that order is exempt from criminal liability. 78 of the IPC. Okay. 14th is only Hatcheldi. Head flies off, kills a man standing by. So is this act excusable and is not considered as an offense? And ఇక్కడ section అడిగారు. So it is contained in section 80 of IPC. So answer A is correct. Section 80 of IPC provides that nothing is an offense done by an accident or misfortune if done by if while doing a lawful act with proper care and caution. Okay. So note for 2026 candidates ఏంటంటే IPC has been replaced by BNS 2023 and BNS equivalents ఏంటంటే section 80 of IPC accident and doing lawful acts is BNS section 38. 84 IPC is 22 BNS. 81 IPC is 34 BNS. బాప్రే చాలా డిఫరెన్స్ ఉంది. Section 85 of IPC intoxication is 23 of BNS. Okay. Shall I go to the next one?
Yeah. Yeah, we'll just do this and close.
Okay. Next is abetment. Abetment is the act of instigating, conspiring with, or aiding another person to commit an offense. An abettor is criminally liable even if the main offense is not completed. Even if the main offense is not completed, abettor is criminally liable. Okay. So definition and modes. Section 107 of IPC: a person abets the doing of a thing. Who first is instigates any person to do that thing. Second is engages with one or more persons in any conspiracy to do that thing. Okay. Third is intentionally aids by any act or illegal omission the doing of that thing. So a person who instigates any person to do an offense or illegal act attracts section 107 of IPC. This was exam tested. Okay. Okay. 108 of IPC is the abettor. The explanation section important for abetment and abetment where the principal is innocent. Just a moment. Yeah. So 108 ante abettor, the explanation section important for abetment of abetment and abetment where the principal is innocent. Key illustration enti X strikes A. X strikes A. A by provocation is excited to kill Y, a bystander who tries to take advantage. Enti X strikes A. Okay. A by provocation is excited to kill Y. One more person who is a bystander who tries to take advantage. Analysis: A commits murder. Y abets murder by intentionally aiding. Hence, A is liable for murder. Y for abetting the murder. Okay. Three parties you have to remember. I mean, three parties are there in this. So, abettor is also considered as what person who has done an offense. That is 108, 107. Okay. Next one is abetment of suicide. Section 306 of IPC, abetment of suicide. Whoever abets the commission of suicide of any person shall be punished with an imprisonment up to 10 years and a fine. So, abetment of suicide is dealt under Section 306 of IPC, not Section 7, 8, or 9. Exam tested. None of the above. 306. 7, 8, 9 ekkada, 306 ekkada.
I think one of our professors in the college was very close for section 306.
Abetment of suicide. Oh God.
Abetment of suicide.
Ayyo.
వాళ్ళు పెట్టిన టార్చర్ ఎవరండి రెస్పాన్సిబుల్?
Ayyo.
Go ahead.
306. Okay, I'll read the questions.
Yeah.
So first one is a person instigates any person to do an offense or illegal act or omission attracts 107. So abetment by instigation. ఇదంతా ఇంకా we have to check the bare acts only. Sections అడుగుతాయి. If you can remember, good. Note for 2026 candidates ఏంటంటే IPC has been replaced by BNS and BNS equivalents is 107 is section 45 abetment. 120B is section 61. 114 of IPC is section 48. Section 144 is 187 of IPC. ఇక్కడ connection లేకుండా ఉంది అసలు. Unlawful assembly. Okay. Second question is abetting the commission of suicide is given under section 9, 8, and 7. So all of them are wrong. So అందుకనే answer is none of the above. So 306 లో వస్తుంది. Abatement of suicide is dealt under 306. Okay. So 306 IPC దేంట్లో వస్తుంది BNS section అంటే 108. Okay, that is given a note for 2026 standards. And question 3 is X strikes A. A is by this provocation is excited to violent rage. Y, a bystander intending to take advantage of A's rage and to cause him kill X, gives a revolver into A's hand. Bah. Okay, gives a revolver into A's hand for that purpose. A kills X with a revolver. So options ఏంటంటే A is liable for committing murder and Y is liable for abetting the murder. అదే ఆన్సర్. A is liable for committing culpable homicide and Y is not liable. What is the difference between culpable homicide and murder? నేను మర్చిపోయాను.
కల్పబుల్ హోమిసైడ్ లో మెన్స్ రియా లేదు కదా. మర్డర్ ఇందాక మనం డిస్కస్ చేసాం కదా, కల్పబుల్ హోమిసైడ్ ఇస్ లైక్ యాక్సిడెంట్ చేసాం అనుకోండి, అది మర్డర్ కాదు. దెన్ దే విల్ బి అండర్ కల్పబుల్ హోమిసైడ్.
No mens rea is culpable homicide. Okay. Sorry. C is A is liable for committing culpable homicide and Y is liable for abetting culpable homicide not amounting to murder. A is not liable, Y is liable for abetting the murder. So this answer is A. Because A is liable for committing murder. So because he has already killed X, and Y is liable for abetting the murder because he takes advantage of A's rage.
అంటే ఇక్కడ క్వశ్చన్స్ లో దే ట్రై టు కన్ఫ్యూజ్ us. అంటే వాడికి బేసికలీ ఏకి దేర్ ఇస్ నో మెన్స్ రియా కదా, సో కెన్ ఇట్ కల్పబుల్ హోమిసైడ్ అని కూడా అనుకోవచ్చు కదా. సో అందుకని అలా చెప్పారు అన్నమాట, కన్ఫ్యూజ్ చేయడానికి. అంటే మనం అంత చదువుకోలేదు, కన్ఫ్యూజ్ కూడా అవ్వం అనుకుంటున్నాం. ఇది మన అడ్వాంటేజ్.
God.
Yeah. So that's what it is. So we'll end today. So many sections today. I think we'll do tomorrow.
Many sections. Yeah.
Yeah. మహేష్ గారు ఉన్నారా, వెళ్ళిపోయారా? సరే సార్, ఈరోజు రేపు స్టార్ట్ చేద్దాం మళ్ళీ.
ఓకే అండి, థ్యాంక్స్.
ఎలాగో వి రీచ్డ్ అరౌండ్ 271 pages సార్. ఇలా చదువుకుంటా పోతే 1 week లో అవగొట్టేస్తుంది. మళ్ళీ రివిజన్ చేసుకుంటాం.
సార్ 40 మార్క్స్ కావాలా, 30 మార్క్స్ కావాలా?
45 అనుకుంటాం.
45.